And for the African Nova Scotia Justice Institute in the SB case, Brandon Rolle.
Thank you, Chief Justice and Justices. The legacy of systemic anti-Black racism means that Black youth experience the criminal justice system differently. When considering the most severe sanction available under the YCJA, their unique circumstances must be meaningfully accounted for. It was 10 years ago that the first Impact of Race and Culture Assessment, or IRCA, was considered in an adult sentence application in the case of RVX. In that case, Judge Derrick, as she then was, found that the social context evidence brought forward in the IRCA allowed her to view the African Nova Scotian youth in front of her through a different lens, and that it critically informed her analysis about whether he should be sentenced as an adult. And I think that context is important because we've heard comments today about the Morris framework, and I would just commend the 2021 Nova Scotia Court of Appeal Anderson case to this honorable court when considering how to apply social context evidence in the adult sentence analysis. I do want to speak to a couple of questions that were raised earlier. Justice Rowe, you made the observation that the systemic and background factors do not automatically equate to reduce moral culpability. And of course, we would agree with that. That is the artificial reduction of sentence that was discussed in IPLE and rejected by this court. And we agree, of course, there has to be some connection between background factors and the particular circumstances of the offender and the offense, but that is not a high bar and certainly not a causal link that needs to be established. And that's cited at Anderson at paragraph 118 and also at Morris, Ontario Court of Appeal decision at paragraph 96. And we say this underscores the need for social context evidence revealed in an IRCA, that connection between the general circumstances and the specific circumstances of the offender. So in my time, I want to agree with the appellant in saying there is a legislative foundation in the YCJA that measures taken against a young person must respect ethnic and cultural differences. And we say that's a clear directive to consider the unique systemic and background factors of Black youth in sentencing. And we say this is also necessary because of the legacy and impact of systemic anti-Black racism. This court has many times acknowledged the pernicious nature of racism and its devastating impact in cases like RDS, Spence, and more recently in Lee. And of course, IPLE says that systemic and background factors are relevant sentencing considerations for non-Indigenous offenders. And most recently in Hills, this court acknowledged that Black offenders are overrepresented in the criminal justice system, and experiences of historic and systemic disadvantage may reduce moral blameworthiness. And indeed, the available data shows us that Black youth are incarcerated at a rate of over 2 to 1, excuse me, compared to their presence in the general population. So while sentencing judges can and should take judicial notice of anti-Black racism, connecting that history to the lived experience of a Black young person can only be achieved, we say, through the meaningful application of social context evidence. When it comes to how the court should receive this evidence, we do urge this court to find that an IRCA impact of race and culture assessment is an indispensable tool. And we say that because there is a danger of the social context evidence not otherwise being presented to the court. And we see that in the RVX case that I referenced earlier, wherein that young person had 3 Section 34 reports, a PSR, a pre-sentence report, none of which discussed integral parts of the young person's identity, namely his race and culture. We know that IRCAs are prepared to a high professional standard, that the government's provided funding to deploy these in every jurisdiction across the country, and we say they illuminate the ethnic and cultural differences that sentencing judges are required to consider. In the time that I have left, I'll just address how to apply this social context evidence to the Section 72 sub 1 analysis in our view. And we say that is a holistic application and that a contextual approach is relevant at both prongs of Section 72 sub 1. At the first prong, we say that you cannot have an individualized assessment of diminished moral culpability for Black youth without considering social context evidence. Any factor that may be relevant to this analysis can be informed by an IRCA, and we've given specific examples of that at paragraph 28 of our factum. At the second prong, we say that the purpose and principles of sentencing which are engaged by Section 72 sub 1 sub B must also be considered through this IRCA lens. And we've provided an example of this approach at paragraph 35 of our factum. Accountability for young people is linked to their inherent vulnerability. They are differently accountable, as Justice Abella said in DB. And we say social context evidence helps us understand the unique vulnerability of Black youth and how to hold them accountable. And finally, we say that sentencing judges should be directed to explicitly detail in their reasons how the social context evidence revealed in IRCA has been applied to their analysis. Thank you.
Thank you.